So very good day to all of you. So this is our video, which is second in the series of the video relating to the video evidence. In the first video, we have discussed about the challenges which are relating to the video evidence. What are the challenges? So in the same category, in this session, we are going with the first challenge, that is the admissibility of the video evidence. And I tell you that it is one of the biggest challenges. Let me share my slide with you. So admissibility is one of the biggest challenges as compared to the other challenges. Why it is biggest challenge? Because if something is not admissible, the court will not look into at all. You may have a genuine video, you may be filing the original video, but if it is not admissible, if you have not properly presented, then the court will not look into that evidence. So relevancy would precede the admissibility. So first you have to show to the court that the evidence which you are relying upon is admissible. The second thing is that admissibility will precede the authenticity and reliability. So that means first you have to prove the admissibility, then only the question of authenticity and reliability will come. Third thing which we are going to discuss is how the objection to the admissibility is to be raised. So if you are the person who are proving the evidence, then you must know what are the objections which you are likely to encounter. And if you are the person who is on the opposite side, who want to challenge the admissibility, then you must know how to challenge it. So the primary evidence would be admissible by virtue of section 62 of the Indian Evidence Act. However, for the secondary evidence, now we have the two provisions. First is section 65B of the Evidence Act, and second is section 63 and 65 of the Indian Evidence Act. So first I am coming to one of the significant and the prominent judgment of the Supreme Court in Anwar PV versus P.K. Bashir, where the very important proposition have been laid down, and there are three takeaways from this particular judgment. The first is that if you are filing the original evidence, which is a original electronic record in the eyes of law, which is a primary evidence, so it would be admissible under section 62 of the Evidence Act. But if you are filing a secondary evidence, which in the form of a copy of the video, which is either CD, DVD, pen drive, or any other optical or magnetic media, then it would be admissible by virtue of section 65B of the Evidence Act. But if there is no certificate under section 65B, then it would not be admissible at all. The another important proposition is that if there is no certificate under section 65B, then anything which emanates out of this would also not be admissible. For example, if you have filed a DVD or CD containing the video without 65B, it would not be admissible. But at the same time, any witness or you cannot refer to any image or any scene from that particular video or any audio component from that video. So whatever which emanates out of it would not be admissible. Now coming to section 65B of the Evidence Act, it is a non-obstante clause. It pervades over the other sections. It says if there is any secondary evidence, for example, in the form of CD, DVD, or any optical or magnetic media, it would be admissible without production of original, provided the condition relating to the information and condition relating to the computer are satisfied. So let us first come to what are the condition relating to the information. So condition relating to the information are that condition relating to the computer are that computer is being regularly used to store the information. Second, for the activity or the information which is being regularly carried out. So that is another requirement. Third, it is under lawful control. And fourth, it was operating properly at the relevant time when the electronic evidence is produced. So these are the four conditions. Now coming to the condition relating to the information. So it says that the information should have been produced in the ordinary course of it. And the second is that the information is derived from the information which is fed into the computer. So these are the two conditions relating to the information. Now we are coming to subsection 3, which laid down very important proposition. So there are two propositions which is being laid down. Number one, let us take an example that if I am having a ATM card of State Bank of India and I go to the ATM of the PNB machine, PNB bank, I withdraw some money. So how the transaction is carried out? From the PNB ATM machine, the data will go to the PNB server, then it will go to the State Bank of India server, then it will take it to my account. So if we observe closely, then when the data travel, it will travel through the number of computers. So this section laid down the proposition that when there are a number of computers in succession, then they would be treated as one computer for the purpose of section 65. Second is that if there are a number of computers in a network, which may be LAN or WAN, they would be presumed to be one computer. So these are the very two important propositions. For example, if you are working in any organization and a particular document is being created, it may be possible that the 5 or 10 person from the different department may be working on that particular document. Okay? So the document is not being produced by a single computer, it is being produced by the combination of computers which are part of the same network. Second proposition is, if you have to take the printout, you may take from any computer which is connected to the server. So in all, for enabling the admissibility of these type of document, where there are number of computers to produce or where there are a number of computers in a network to access and take the printout, the section 65B3 laid down a very important proposition that all the computers in the network would be presumed to be the one computer. Now coming to the what should be the content of certificate, because I am getting so many queries that what should be there in the certificate. So it's very simple. Number one, first thing, when you are drafting a certificate, you must keep in mind that the content of the certificate must contain the description of the record which you want to prove. For example, if you want to prove a video, so you must mention that this certificate is regarding the video which is having the file name, whatever description you have mentioned, produced by which computer, on which date. So that should be the first thing. The electronic report should be identified. Then we have to comply with the condition relating to the computer, relating to the information, which we have discussed in the previous slides. It's very simple. There is no complexity. There is no standard formula for it. There is no such format which is prescribed under the law which must be complied. The only thing is it must contain these three information, and you can write in your own word and in a very simple. But you need to be very clear about it. Number one, it should comply with the identification of the record. What is the electronic report regarding which the certificate is given. Second, regarding the source, description about the computer. And third, the condition relating to the computer and information. So you can always write in your own words. And in the last, you can write that it is true to the best of my knowledge and belief. It is not required to be certified. It is not required to be attested by anyone. You can give it on a simple plain paper. It is not required to be an affidavit. Though in civil cases, because where the evidence is filed by way of the affidavit, now there is a practice to file it by way of the affidavit. Then coming to who is the competent person who can give the certificate. So there we have the two categories of the person who can give certificate. Number one, the person who is into a official position relating to the device. So basically the person who is in charge of a computer. Another thing which you need to understand is when we say that when there are number of computers which are connected in a network are presumed to be one computer. So that means all the person who are in charge of all the computers which are connected in a network can give that certificate because they have access to it. Second would be the person who is not in charge of the computer, but who is the head of the organization. For example, if you take the example of any company, so then IT head or even managing director, but provided he would be in a position to explain what are the relevant activities. He would be able to explain how the data is being maintained in the organization. So if we take the example of police station, then even head SHO of the police station can give that certificate provided he has that knowledge. And if he is giving certificate, he should be mentally prepared that whenever he will come to the court, he has to explain all these questions, all these issues before the court. Now coming to the another important proposition is, I find that there is a misconception, very strong misconception on the part of the police, on the part of prosecutor, and even I've seen in some of the court that admissibility is being taken as a proof for the authenticity also. Or there is no distinction which is being made between the admissibility and authenticity. Or in other words, we say when people are filing it with the certificate under section 65B, probably they presume that it will make this evidence reliable. So I'm telling you one thing, admissibility is only the one component. It has nothing to do with the authenticity. So whenever you are filing any evidence in the court with a certificate under section 65B, you must also keep in mind whether you are in a position to prove the authenticity or not. So how the authenticity is going to prove, that we will discuss in our next video. But that line of demarcation must be clear to you. Another important proposition which always comes is that what would be the objection? Another important proposition is that what would be the fate if I confront a witness with the evidence in the court. For example, I know a witness is speaking false, and I have made a recording outside the court or in some meeting or where I met with that particular witness. Now I have a material in my hand with which I can confront, I can prove that this witness is speaking false. So what is the requirement is that I can simply, during the cross-examination, I can run that video and confront it. Till that, we have to look it from two perspectives. Number one, if the witness admit, then no certificate under section 65B is required and no authenticity is required to be proved. But if the witness deny, the burden would be on us to prove the authenticity and also to comply with the certificate under section 65B. So the best way to do is, if you are going to confront a witness with any video evidence or video recording, there are two methods. Number one, that you must either take the original evidence, primary. Second, if you are taking a secondary evidence, you must take some authenticity certificate in the form of a forensic report, and also attach a certificate under section 65B of the Evidence Act. Objection to the inadmissibility. Now, if you are relying upon a certificate under section 65B, the opposing party may raise an objection that it is inadmissible. So that objection, at what stage it has to be raised, how it is to be raised. So these are the issues. So first thing we need to understand that there are two types of objection. Objection number one is that the document itself is not admissible, like a photocopy. In such case, the objection can be taken at any stage. Second is the objection as to the mode of proof. Mode of proof means objection regarding the authorship. For example, I can say that you are not competent to give a certificate under section 65B. I want to say that you are not in charge of the computer, so you cannot give a certificate. I want to say that this evidence has not been taken from this particular computer, so you are not competent to give a certificate under section 65B. This is the objection as to the mode of proof. So, the Supreme Court in the judgment of Sonu versus State of Haryana has stated that the objection of non-compliance of certificate under section 65B, or when there is no certificate under section 65B, would fall into the category of the mode of proof. So that means you have to raise that objection when the certificate under section 65B is being exhibited by the witness in court of law. But what if you forget to give at the time of when it is being exhibited, put it at the time of the cross-examination. But you must put when the evidence, when that particular witness who is proving that video evidence is in court, you cannot raise that objection subsequent. So that must be clear. So now we have another judgment of Shafi Mohammed versus the state of HP, where the Supreme Court has stated that certificate under section 65B is not mandatory. So now we have the two judgments. In Anwar PV, the court said it is mandatory. In Shafi Mohammed, the court said it is not mandatory. Right? But there is no confrontation among the two judgments. Both judgment operates in their own sphere and both are correct. So in Anwar PV, the certificate is mandatory when the person is in possession of the original evidence. But the Shafi Mohammed says when the original evidence is not into the possession, then certificate under section 65B is not mandatory. For example, now you are going to give any evidence in the form of printout which is taken from a website. You have taken the printout from the website, but whether the original data of that website is into your possession? No. In whose possession it is? It is into the possession of a website owner. So in that situation, you cannot give a certificate under section 65B. But what does it mean? Whether you are not required to comply with anything? No. You are required to comply with the procedure under section 63 and 65 of the Indian Evidence Act. So what is that procedure? We will discuss in detail in a separate session. So thank you very much. And our next video on the video evidence will be on the authenticity. Then we will come on that particular how to prove it false. So we have divided that video into two parts: prima facie forgery and forgery which can be determined with the advanced forensic techniques. So for all my webinar, for all my updated videos, you can always follow me on my Twitter account, Neeraj. So these are some of my social media links which you can always follow. And this is all for the today's session. Thanks to all of you. And I will wait for your questions on this issue. You can always post on my YouTube channel. You can post on my Twitter channel. You can post on my website www.cyberpundit.org. Thank you. Thanks to all of you.